Well, thank you very much indeed, Mr. Evans. And can I just say it's a great pleasure to follow the Right Honourable Lady, the member for Maidenhead, who spoke so powerfully on the issues that are right at the heart of this bill. And I think I pay tribute to the outstanding work that she does in this area around modern slavery and trafficking. So here we are again, Mr. Evans, back for a second day of debate with all across this House agreed, I think, that we need to stop the dangerous small boat crossings and to destroy the criminal industry at the heart of them. And yet each of us knowing, if perhaps not all of us admitting, that this bill is a con and a sham that will only make a bad situation worse. This is because the government does not have any returns agreements with the EU to replace the one we were part of before Brexit, nor a working deal with Rwanda, with the Home Secretary failing in her mission last weekend to persuade Rwandan officials to specifically state that that country can take thousands rather than hundreds of asylum seekers sent from the UK every year, although at least the Home Secretary did get to have a photo op outside some houses that are being built for Rwandan citizens. In order for a deterrent to be effective, it has to be credible, Mr. Evans. And there is next to nothing in this bill that is remotely credible, because it's about chasing headlines and government by gimmick, when what we need is common sense, hard graft and quiet diplomacy, so that we can really go after the people smugglers upstream and do a deal on returns and on family reunion. What we need, Mr. Evans, is Labour's 5-point plan, which will stop the small boats crossings, clear the Tory asylum backlog, and re-establish a firm, fair and well-managed asylum system. Mr. Evans, I said yesterday that this bill was being rushed through this House at such a speed as to make detailed consideration and debate almost impossible. That applies perhaps even more to today's session than yesterday's.
I note what the Shadow Minister is saying about quiet diplomacy. Well, it seems to me, actually, that the Prime Minister has a very good, cordial relationship with the President of France, but it's quite clear that that alone won't be enough to sort this problem out.
Well, the party opposite has spent the last 5 or 6 years completely destroying our relationships with our European neighbours and partners. So any improvement on that is, of course, very welcome. But I feel that the Prime Minister has an uphill struggle on his hands, given the very low base from which he is starting. I will give way.
Can I just say to the honourable gentleman, he said we'd spent the last 5 or 6 years destroying our relationship with France. Perhaps you might like to reduce that by, I think, 2.
Can I say to the Right Honourable Lady, that's one of the best interventions that I've ever received, and I am more than happy to stand corrected, and hereby I hope that Hansard will correct the record accordingly. That's completely knocked me off my stride now. As a result, I will again have to limit my remarks to the amendments and new clauses tabled on behalf of the opposition. Clauses 2 to 5 of this bill establish legal duties which are sure to be unworkable for the Secretary of State to ensure that every single person who arrives in the UK without prior authorisation is held in detention and then removed from the UK. Now, I use the word unworkable advisedly, since the questions I put to the Minister at second reading about where these people will be detained and where they will be removed to are still unanswered. Likewise, we have no idea how much these proposals, if implemented, would be likely to cost. We assume that impact assessments modelling the potential costs have been carried out. But since the government has failed to publish these assessments, thus denying the House its democratic right to hold a fully informed debate on these matters, then we have only various leaks and briefings to the pro-Tory media to go on. We know from these briefings, along with independent third-party analysis, that the bill's price tag is likely to be at least £3 billion a year, and possibly more. But the fact that those impact assessments have not been made public suggests a deliberate attempt on the government's part to limit the scope for parliamentary scrutiny and to obfuscate its own calculations of the amount that will have to be paid by the British taxpayer. So I ask the Minister, What is he afraid of? Why will he not publish this vital information? It's simply not good enough, both for members of this House and for the constituents that we represent. As a result, we've had to table new clauses which would force the government to publish within tight timescales the impact assessments which are clearly being sat on by ministers. All we're asking for in Amendments 286 and 287 and New Clause 28 is for ministers to publish detailed assessments on the likely implications of this bill in terms of cost to the public purse and availability of adequate accommodation and detention capacity so that we can have a fully informed debate. Looking beyond detention capacity, we know that the asylum backlog alone means there will continue to be a need for some time for accommodation to be provided to families who would otherwise face destitution. In recognition of that, New Clause 27 would make it a legal requirement that local authorities be consulted as part of the process of accommodation being provided in their areas. Now, I know that there are strong feelings about this issue on both sides of the House, and on that basis I do look forward to cross-party support for New Clause 27 as we go through the division lobbies this evening. On the basis that sunlight is the best disinfectant, we're also calling in Amendment 284 and New Clause 22 to oblige the Secretary of State to report regularly to Parliament on the government's progress towards clearing the ballooning backlog of asylum cases, an issue that's not even mentioned in this bill, and on the number of people removed from the UK under its provisions. Now, the backlog, as we all know, is 8 times as high now as it was when it was handed over to the Conservatives by the Labour government in 2010, as confirmed by the UK Statistics Authority and contrary to what ministers have been claiming from that dispatch box. 166,000 cases unresolved as of today, only half of which relate to small boats, it must be said. It's an astonishing abdication of duty. So if the government truly believes that clearing the backlog is a priority, then I can think of no good reason for them not to accept the reporting requirements that we have laid out in our amendments. The scope of some of the bill's key provisions, particularly those that relate to detention and removal, is exceptionally broad. What the government is proposing is to do away with virtually all existing safeguards, many of which they themselves established in law within just the last few years, and which many of our amendments are designed to protect. Amendment 148 would remove from the bill the Secretary of State's powers to remove unaccompanied children from the UK. Now, the government says it does not currently plan to use these powers, but if that's the case, then what are the powers doing in the bill in the first place? Amendment 21 would retain the current time limits for the detention of pregnant women, established by the party opposite in its own Immigration Act of 2016. Ministers have not made any case, let alone a convincing one, for scrapping these limits and thus allowing pregnant women to be detained indefinitely. Additional safeguards we're calling for in our amendments include exemptions from the duty to remove in cases where, in Amendment 285, there is no realistic prospect of a person's removal due to the absence of the necessary returns agreements. In Amendment 6, where the person's cooperation with law enforcement could help with efforts to tackle crimes such as people smuggling, and in Amendment 13, where the person's removal is not possible without violating the Refugees Convention prohibition of refoulement. Removal to third countries designated as safe is obviously a central part of the government's plans, even though no country other than Rwanda has so far expressed any interest whatsoever in being part of a similar deal with the UK. But in the event that there are similar deals, we believe there should be certain rules in place to prevent the Secretary of State ignoring evidence of the dangers some migrants may face if removed to the country in question, as has clearly been the case with Rwanda. For instance, Amendment 17 would add to the bill a requirement that the Secretary of State must consult with the UNHCR and other relevant experts when designating safe countries, rather than cherry-picking evidence that supports decisions that she has already made. Amendment 6, together with New Clause 21, form part of a package of new approaches intended to strengthen the government's hand in ensuring the detection, prosecution and conviction of those guilty of people smuggling. Taking ministers at their word that they are serious about dealing with these issues, I look forward to the government's support for these amendments. Mr. Evans, as I have said, the intention of most of our amendments and new clauses is to ensure that robust safeguards are in place to prevent the broad powers being given to the Home Secretary are not being exercised completely arbitrarily. In addition to those I've mentioned already, Amendment 18 would ensure that notices of removal should be provided to people in a language they can understand and with information about their rights and where they can access advice. Turning now to the modern slavery sections of this bill, I would start by reminding the government of the words of the Right Honourable Member for Maidenhead, not just in the powerful speech that she just made in this committee stage, but also at second reading, when she said, "Nobody wants to see our world-leading legislation being abused, but the government have to set out the clear evidence if they're saying that there is a link between that act and the small boats. And so far, I have not seen that evidence. And I would say that she is not the only one, Mr. Evans, as we on these benches have also yet to see any evidence to that effect." The Right Honourable Member for Maidenhead also correctly pointed out that significant changes were made to modern slavery legislation by the Nationality and Borders Act, the relevant sections of which have only come into force within the last few weeks, and that further changes at this point are clearly unnecessary. That is the point we are making with a number of opposition amendments to these sections of the bill. For instance, Amendment 24 would keep in place the definition of public order provided by the Nationality and Borders Act, which states that modern slavery protections do not apply to people who pose threats to public order, such as violent criminals or terrorists. The bill seeks to extend the definition of such threats to literally anybody who arrives on a small boat. It is far from clear that this is what the Trafficking Convention had in mind when it provided for exemptions to the general requirement to make protections available to victims. For that same reason, we do not believe that support for victims should be withheld from people who would otherwise be subject to the duty to remove that the bill establishes. Those provisions of the bill would be removed by our amendments 288, 289 and 290. Amendments 291 and 292 are more targeted and would provide specific exemptions for victims of sexual exploitation and prevent the removal of victims who are not parties to the ECHR and the Convention Against Trafficking. New Clause 30 recognises that potential victims of trafficking may be particularly vulnerable to serious harm if held in detention for indefinite periods. On that basis, New Clause 30 calls for the government to implement special procedures to fast-track any cases of potential victims whose modern slavery referral first arises while the person is held in detention. The government has sprung these changes on us without any meaningful attempt at consultation. Amendment 50 serves as a reminder to the government that last year ministers made very specific promises not to try to make any changes to modern slavery laws without first appointing a new independent anti-slavery commissioner and consulting with him or her on the potential implications of any proposals. That commitment has not been honoured, and Amendment 50 goes no further than asking ministers to keep to their own promises. It would simply delay the entry into force of the relevant sections of this bill until after a new commissioner has been appointed and consulted and their views taken into account. And whilst we're on the topic of the Modern Slavery Commissioner, it is of course worth noting that the former Modern Slavery Commissioner, Sarah Thornton, has stated that if you remove support for modern slavery victims coming forward, you make it harder to prosecute criminals. I spoke earlier about attempting to amend the bill to provide certain safeguards. Ultimately, all the safeguards in the world are unlikely to substitute for the requirement that measures should comply with basic human rights, as enshrined in the Human Rights Act of 1998. The Secretary of State has been all over the place in various announcements in which she seems to contradict herself on the question of whether this bill, if enacted, would be compliant with human rights law. Amendment 1 simply says that requirement, which applies to all other legislation, should apply to this bill too. Ministers should have nothing to fear from this amendment, unless, of course, they doubt their own statements to the effect that they are confident in the bill's compliance with human rights law. Mr. Evans, as it stands, this bill is a trafficker's charter. We therefore urge the government to support our amendments and new clauses so that we can remain true to the values and principles that underpin the Modern Slavery Act. Mr. Evans, I'll just end with a few reflections on yesterday's debate, because I do have to say that I found some of the comments made by the benches opposite deeply troubling. Many talk a good game on defending Ukraine and Hong Kong and other democracies around the world from authoritarian threats, but they're sometimes not as good at defending their own democracy. Indeed, they seem to be focused on undermining it. I'm yet to hear a definitive definition of an activist judge. From what I can work out, this is simply a judge who makes a ruling that the government disagrees with. I'm yet to hear any definition of a lefty lawyer. I think it's someone who has picked apart and defeated the weak case that the Home Office may have put together, despite the thousands of experts that it has at its disposal. And I'm yet to understand how we define the Home Secretary's civil service blob. Are these the people that work for her day in and day out, a number of whom are in junior, low-paid roles, being asked by senior ministers to make complex asylum decisions because of cuts made by the Conservatives 10 years ago? I ask these questions, Mr. Evans, because the separation of powers and the functioning of these powers is absolutely critical to our Constitution and to our democracy. Yet many members on the benches opposite are increasingly sounding like their right-wing counterparts in America, blaming every institution for their own failures, terrified of scrutiny from the media, unable to do their jobs within the law because they either don't understand the law or because they've been over-promoted. Mr. Evans, I'm not a lawyer, and I'm not making these points from a legalistic perspective, but I am a Democrat. And when I hear the tirade of abuse that the benches opposite hurl at our judiciary during debates such as the one that took place yesterday, I have to say that it leaves me fearing for the future of our democracy. Because the separation of powers between the executive and the judiciary is absolutely fundamental. And these powers and these checks and balances are axiomatic to our democratic values. So I would urge members opposite to think long and hard before they launch any further assaults on our judiciary, because we don't want to live in a Trumpian version of Britain, Mr. Evans. We want to live in a vibrant democracy that is based on upholding the independence of the judiciary, defending the separation of powers, and respecting the integrity of our institutions. Thank you.